So this training as part of the Domestic Violence Awareness Month programming, it will provide all attendees with an overview of how these regulations impact our community when it comes to addressing matters of this, sex discrimination, and that includes sexual harassment, sexual assault, and domestic violence. Now, before we get started, I'd just like to let you know that the presentation will take about 50 minutes. Sometimes it takes less time than that. And we just ask that all attendees be muted in Zoom during the presentation. So thank you for doing that. Next slide, please. So the Office of Employee Relations and Title IX here at Southwestern College is responsible for overseeing the handling of discrimination and harassment complaints, grievances, all Title IX related matters, including VAWA grant efforts, and we're also involved in leadership initiatives. We take a complaint prevention approach to addressing workplace issues. And the VAWA grant stands for the Violence Against Women Act grant, and it's a grant that the Southwestern College has received from the U.S. Department of Justice. And as part of the grant, we lead a consortium of member institutions in the San Diego County area in our efforts to raise awareness about violence against women issues such as domestic violence, sexual assault, etc. Okay, next slide, please. So a little bio about me. I come from a civil service background. I have a master's degree in education from UCLA. I was a teacher in Los Angeles County before I segued into service with the federal government. And I worked a number of years with the federal government, including as an investigator for the Equal Employment Opportunity Commission, where I investigated claims of workplace discrimination and harassment. I was also an investigative analyst and a management and programs analyst for the Department of Homeland Security. I came aboard to Southwestern College in November of 2019, and this is my first time working at an institution of higher learning. So I'm very happy to be here. Thank you. Let's move on to the next slide, please. So here are the topics or objectives we're hoping to cover with you today. We will be looking at what is Title IX, Title IX scope, the Clery Act, VAWA, and the Campus Save Act, what is sexual harassment, what is affirmative consent, the Title IX process at Southwestern College, the role of the Title IX coordinator, who is required to report Title IX offenses, and how can you help to support the Title IX process. Okay, next slide, please. So what is Title IX, you may be asking? Well, let's, next slide, please. Title IX of the Education Amendments Act of 1972 is a federal law that prohibits discrimination on the basis of sex in educational programs and activities. According to Title IX, no person in the U.S. shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subject to discrimination under any education program or activity receiving federal financial assistance. Next slide, please. So essentially, Title IX prohibits discrimination on the basis of sex, and that extends to discrimination based on pregnancy and parental status as well. This means that all types of educational institutions receiving any federal funds must comply with Title IX, and schools must respond promptly and effectively when it learns of any form of possible sex discrimination, including sexual harassment, such as sexual violence and gender-based harassment. Okay, next slide, please. So now we'd like to discuss in detail Title IX's scope. Next slide, please. So who is covered under Title IX regulations? There is coverage for all enrolled students, including part-time and full-time students, all college district employees, regardless of their classification or position. It also covers interns, volunteers, and in certain cases, even visitors to the campus. However, in order to trigger a Title IX response, the alleged incident must have occurred within the US. In addition, the individuals involved in the alleged incident must also be participating in any educational program or activity controlled by the college district, including buildings or properties controlled by recognized student organizations. So a Title IX response is warranted when the alleged incident takes place on campus, or if off campus, it must have been at a college district sponsored event. Next slide, please. So here is a list of various types of conduct that would fall within Title IX scope, and it is by no means an exhaustive list. This list includes sexual harassment, such as quid pro quo harassment, hostile environment harassment, and sexual violence. And we will go into more detail about sexual harassment in just a bit. Covered conduct also includes sex or gender-based harassment, such as stalking, hazing, bullying, arson, vandalism, and theft. Additionally, gender discrimination with a focus on equity generally refers to disparate treatment of students in male athletic programs versus female athletic programs. And as noted previously, pregnant and parenting individuals are also protected from discrimination by Title IX. And lastly, I'd just like to draw your attention to that point labeled in red, the point that any other policy violation that is sex or gender-based that causes a discriminatory effect would trigger a Title IX response. Okay, next slide, please. Now, there has been a flurry of activities in 2021 regarding if Title IX protections are extended to members of the LGBTQ community. In January of 2021, the Trump administration's Department of Education issued a decision stating that Title IX regulations do not apply to discrimination based on someone's gender identity or sexual orientation. However, since then, the Biden administration has issued a pair of executive orders on January 20th and March 8th, 2021, that reversed the Trump administration's prior decision. So these two executive orders expanded Title IX scope to include prohibition of gender identity or sexual orientation discrimination. Furthermore, recently in April of 2021, Department of Justice memo cements the determination that Title IX prohibits discrimination based on those protected classes. Okay, thank you. So next slide, please. Now, we'd like you to take a brief poll on the following question. Is this complaint within the jurisdiction of Title IX enforcement? Hector, who is a student at Southwestern College, emails the Office of ER and Title IX a complaint, alleging that during summer break last year, while he was at a house party in Rosarito, Mexico, another Southwestern College student touched his buttocks. Hector asked the Office of ER and Title IX to investigate the matter. So yes or no, is this complaint within the jurisdiction of Title IX enforcement? And I believe Yen will bring up a poll, right? Yes. So if you could answer this question by choosing the answer that you feel answers the question, that'd be great. Okay, thank you. So we have 38% of our attendees answered yes, while 63% of our attendees answered no. Okay, so what is the correct answer? So the correct answer is no. This complaint is not within the scope of Title IX enforcement. Firstly, the alleged incident took place outside of the US. Secondly, the alleged incident occurred off campus at an event not sponsored by the college district. And even though both Hector and the alleged perpetrator, who we commonly refer to as a respondent in Title IX speak, even though they're both Southwestern College students, because the incident took place outside of the US and in a context or setting outside of the college district's control, it does not fall within the jurisdiction of Title IX. Therefore, the matter would not be investigated by the Office of ER and Title IX, And again, we'd like to emphasize that the new Title IX regulations made effective in August 2020 added this caveat that the alleged infraction must have occurred within the US for the matter to be investigated under Title IX stipulations. Okay, so everyone, thank you so much for taking part in our poll. Let's move on to the next slide. Okay, so now we'd like to briefly delve into several regulations that you may have heard of in conjunction with Title IX. Next slide, please. So a little bit about the Clery Act. The Jean Clery Disclosure of Campus Security Policy and Campus Crime Statistics Act of 1990 is commonly known as the Clery Act. So a little bit about how this law came into place. The law is named after Jean Clery, who was a 19-year-old Lehigh University student. She was raped and murdered in her campus residence hall in 1986. And her murder triggered a backlash against unreported crime on campuses across the country. So the Clery Act requires all colleges and universities that participate in federal financial aid programs to keep and disclose information about crime on and near their respective campuses. And the compliance is monitored by the United States Department of Education. And you can see here a list of what institutions are required to provide under the Clery Act, which includes crime report and campus crime log, instituting a campus sexual assault victims bill of rights, and that was enforced in, or that came into being in 1992, making policy and procedure disclosures, giving timely warnings and emergency notifications, and disseminating information about sex offenders. Please note that this is a separate and distinct law from Title IX. Okay, next slide, please. Now, the Violence Against Women Act, or VAWA, is another distinct law from Title IX that was passed in 1994 to improve criminal, legal, and community-based responses to domestic violence, dating violence, sexual assault, and stalking in the US. The key point about VAWA is that it's renewed every 5 years, and each reauthorization sort of builds on existing protections and programs. That means, with each reauthorization, there might be new protections or programs enacted as part of that reauthorization. So next slide, please. So how do these separate laws all tie in with each other? Well, a reauthorization of VAWA in 2013 significantly amended the Clery Act by imposing new regulations on institutions under its Campus Save Act. And this created requirements for colleges and universities to address issues in the areas of sexual assault, stalking, dating violence, and domestic violence. It also prohibited retaliation against complainants and reporters. In terms of Title IX, legal definitions for sexual assault, stalking, dating violence, and domestic violence in the new Title IX regulations, which we call Title IX Final Rule, that was made effective in August 2020. Those legal definitions all come from the standards set forth in VAWA and the Clery Act. Okay, next slide, please. So to better illustrate how the Clery Act and Title IX intersect, here's a Venn diagram showing that intersectionality. You could see that the VAWA crimes are included in both the Clery Act and the Title IX Act. Both acts also require schools to provide victims of sexual violence with information in writing about options for and available assistance in supportive and protective measures. Both acts also guide disciplinary procedures for sexual violence incidents. Both acts require schools to explain the types of proceedings, steps involved, and timelines for such proceedings within their policies. Both acts require training for individuals involved in disciplinary proceedings. And both acts state that certain individuals have reporting responsibilities when they become aware that sexual violence has occurred. And we will get to this reporting responsibility in just a bit. Okay, let's move on to the next slide, please. So now we're going to talk about sexual harassment under Title IX. Next slide, please. Okay, what is sexual harassment? Well, under Title IX, sexual harassment is defined as unwelcome conduct that is based on sex, which must meet one of the following conditions. In the case of quid pro quo harassment, a school employee conditions education or employment benefits on an individual's participation in the unwelcome sexual conduct. For hostile environment harassment, the unwelcome conduct must be one where a reasonable person determines it is so severe, pervasive, and objectively offensive that it effectively denied a person equal access to the school's employment or education programs. Lastly, and this is where domestic violence comes in, sexual assault, dating violence, domestic violence, or stalking falls into the third category of conditions that must be met for the unwelcome conduct to be classified as sexual harassment under Title IX. So as I talked about previously, those definitions for sexual assault, dating violence, domestic violence, and stalking, those come from the VAWA that we talked about previously. Okay, next slide, please. So how do you know when the alleged conduct meets the severe, pervasive, and objectively offensive threshold? Some of these factors that we consider are the frequency of the offensive conduct, the nature of the unwelcome sexual acts or words, whether the harassment was merely an offensive utterance, and also the relationship between the parties involved. So for instance, you know, if something, if an alleged conduct was a remark that an alleged respondent made to an alleged complainant and it was just a one-time incident, it might not meet the severe, pervasive, and objectively offensive threshold for that conduct to be addressed under Title IX regulations. Okay, next slide, please. So as you can see here, we have listed some instances of sexual harassment, and of course, this is by no means an exhaustive list. The key point to remember is that the conduct must be unwelcome to fall within the legal standards of sexual harassment. In other words, affirmative consent must be given and received before any act of or relating to a sexual nature is engaged, and we will discuss affirmative consent in the next section. But before we do so, we're going to take another poll. So next slide, please. So now we'd like you to take a brief poll on the following question. Is this an example of sexual harassment? Tan's co-worker, Sandy, has just been through a divorce. Tan and Sandy have been friendly in the past and have had lunch together in local restaurants on many occasions. Sandy asked Tan to go on a date with her, dinner and a movie. Tan likes Sandy and agrees to go out with her. He enjoys his date with Sandy, but decides that a relationship is not a good idea, and he thanks Sandy for a nice time. And he explains that he does not want to have a relationship with her. Sandy agrees, and both continue to be cordial to each other at work. So yes or no, is this an example of sexual harassment? Okay, thank you. Wow, we have 100% of our attendees answering no, and 0% answering yes for this question. So what is the correct answer? The correct answer is no. This is not an example of sexual harassment. By asking Tan to go out on a date with her, Sandy did not engage in sexual harassment because the act of asking Tan out on a date was not sexual in nature. And even if Tan turned Sandy down for the date, Sandy had done nothing wrong by asking for a date, which was not an act of or relating to a sexual nature. In addition, by agreeing to go out with Sandy, Tan gave affirmative consent to Sandy. Lastly, after Tan told Sandy that he does not want to have a relationship with her, both employees were able to resume their working relationship professionally and amicably. So this was not unwelcome conduct, and there was no sexual harassment. Okay, so let me do this. Okay, thank you again, everyone, for participating in our poll. Let's move on to the next slide, please. Okay, so now we're going to look at what affirmative consent means here in California. Next slide, please. Affirmative consent means an informed, affirmative, conscious, voluntary, and mutual agreement to engage in sexual activity. Here in California, we abide by the following law to determine if affirmative consent has been given in an allegation of sexual assault. And the law states that it shall not be a valid excuse that the accused believed that the complainant affirmatively consented to the sexual activity if the accused knew or reasonably should have known that the complainant was unable to consent to the sexual activity under any of the following circumstances. For instance, the complainant was asleep or unconscious, or if the complainant was incapacitated due to the influence of drugs, alcohol, or medication, such that the complainant could not understand the fact, nature, or extent of the sexual activity, or if the complainant was unable to communicate due to a mental or physical condition. Next slide, please. In addition, coerced consent is not valid when there is intimidation, trickery, force, pressure, manipulation, threats, blackmail, and or use of drugs and alcohol to coerce the victim into consenting. Next slide, please. Again, here are some more examples of what is not considered to be affirmative consent. And you can see that for the last bullet point, the existence of a romantic relationship or sexual history is not indicative of affirmative consent. Okay, next slide, please. Okay, so we're going to now talk about how the Title IX process works here at Southwestern College. Okay, next slide, please. Now, here's a flow chart showing the Title IX complaint resolution process here at Southwestern College. One can see that Title IX complaint could come from numerous sources, including various administrative offices, such as the Office of Student Services, campus police, and even via social media, such as to our college district's social media accounts. All Title IX complaints are forwarded to the Office of ER and Title IX. It's important to emphasize that after we receive a complaint, it goes through an initial review process where we determine if the complaint is within Title IX's jurisdiction. This office would also provide supportive measures to both the complainant and the respondent, and this is a topic that we will cover in a later slide. If the complaint is determined to be non-jurisdictional, this office will refer the complainant to appropriate resources that may be able to assist them and then close and document the complaint. However, if the complaint is within jurisdiction, then the formal complaint option is offered to the complainant. An investigation is initiated upon receipt of a formal complaint, which we will discuss a bit later. The investigation itself is a neutral, impartial fact-gathering process. Sometimes we also say it's a fact-finding process. During the investigation, the complainant, respondent, and any witnesses that either party identifies are interviewed by the investigator. In addition, any documents or evidence provided by any involved parties are also reviewed. Now, after the investigation is completed, a report is issued and shared with both parties along with any directly related evidence. Both parties are also given an opportunity to comment on the report and the evidence, and their comments are sent to the decision maker before a live hearing is scheduled. Following that, a live hearing is scheduled where both complainant and respondent are cross-examined. After the hearing, the decision maker issues a written determination of findings and any recommended sanctions. Lastly, after a finding is issued, both parties have the right to appeal the decision on the basis of procedural irregularity, new evidence, and or conflict of interest. If the appeal is granted, the case is sent back for a rehearing or reinvestigation. If the appeal is denied, then the findings and any sanctions are final. Please also note that we also have what's called informal resolution, and this is an option that may be pursued to resolve a formal complaint with written consent from all parties upon approval from the Title IX coordinator. I should also note here that there's often confusion we get about Title IX investigations versus discrimination and harassment investigations. Okay, because this office handles both areas. Title IX, please know that Title IX strictly covers those areas that we talked about, those areas of sexual harassment, including sexual assault, domestic violence, stalking, you know, that's based on discrimination due to someone's sex. But we also handle complaints of discrimination that may be made based on somebody's other protected class, such as their race, color, national origin, religion, and so on. So, but these are two separate processes. And sometimes there is confusion because, you know, we have complainants bringing forth their complaints, thinking that it is Title IX, when in fact it would not fall within the jurisdiction of Title IX at all, because it is not a concern based on sex discrimination. Also, I should note that the decision maker in this process is not the Title IX coordinator, because according to Title IX final rule, it strictly prohibits the Title IX coordinator from being the decision maker in a Title IX investigation. Okay, so let's move on to the next slide. So here's a list of board policies and administrative procedures at Southwestern College that are applicable to our Title IX process. These policies and procedures are either new or have been revised to comply with changes made to the Title IX regulations back in August 2020. And the ones that we highlighted in red are especially significant for the Title IX process at Southwestern College, such as, you know, AP BP 34, 34, 33, 34, 34, and 35, 40. Okay, next slide, please. So let's talk about how a formal complaint triggers the Title IX response. A formal complaint is a written allegation of Title IX concerns signed by the complainant requesting an investigation. This document triggers the Title IX response. The response may include supportive measures to both parties, which is made upon notice of potential allegations, dismissal if the issues are outside of Title IX jurisdiction, notices of allegations issued to both parties, and an investigation or an informal resolution. I'd like to emphasize that if the complainant does not file a formal complaint, the Title IX coordinator has the discretion to bring a formal complaint against a respondent. However, that Title IX coordinator does not become the complainant. The person who brought forth the original allegation is still the complainant, but that person obviously would not be signing off on that formal complaint. The Title IX coordinator will. Okay, next slide, please. It's very important to note that with the Title IX regulations made effective in August 2020, both the complainant and the respondent are afforded the following rights. They include detailed and specific notice of allegation and or investigation, notice of hearing, right to present witnesses, right to present evidence, right to an advisor of their choice, opportunity to be heard and address the allegation and evidence, right to appeal, right to cross-examination, and right to review all relevant evidence and the investigation report prior to a decision. It's very important to remember that these new requirements reaffirm that the accused is innocent until proven guilty. And that's something very important for us to keep in mind, because oftentimes we come across complaints and concerns where the complainant stresses that the accused is absolutely guilty, and we have to look at the evidence and the facts presented to make that determination. So the Office of ER and Title IX abides by the decree that the accused is innocent until proven guilty. Okay, next slide, please. Let's talk about the standard of evidence. At Southwestern College, the Title IX process uses the preponderance of evidence standard to determine if the policies of the college district have been violated. A preponderance of evidence means if it is more likely than not that the conduct occurred. So this leads us to three types of findings that could be issued after analyzing the facts gathered during an investigation. The allegation sustained finding means when taking all evidence into account, including credibility determinations, it is more likely than not that an allegation is true. Allegation not sustained means there is insufficient evidence to meet the threshold, even if there is some supporting evidence. Allegation unfounded means there is compelling evidence to determine that an allegation is proven to be not true. Okay, next slide, please. Okay, so now we'd like you to take another brief poll on the following question. Does the complainant have a right to appeal? The Title IX coordinator filed a formal complaint. The complainant said he was interested in a no contact directive and a formal resolution. But before any action is taken and any agreement is discussed, the respondent leaves the college. The Title IX coordinator intends to dismiss the case because the respondent is no longer enrolled. Does the complainant have a right to appeal that dismissal since he did not submit the formal complaint? Yes or no? Okay, thank you for responding to our poll. Let's give it a few more seconds. Okay, so we have, I believe, 6 attendees who have responded. Okay, 7. Let's give it a few more seconds. Okay, so we have 7 out of 7 poll takers confirming, answering yes, the complainant has a right to appeal. So what is the correct answer? The correct answer is yes, the complainant still has a right to appeal. As noted in the slide about formal complaints, even though the Title IX coordinator filed the formal complaint, the individual who brought forth the allegation is still considered to be the complainant. Therefore, as a complainant, he has a right to appeal the dismissal, and the standard appeal process would still apply here. Okay, thank you so much for participating in our poll. Let's get to the next section. Next slide, please. So now we're going to briefly look at the role of the Title IX coordinator. Okay, next slide, please. As you can see, the Title IX coordinator is responsible for a large array of duties related to Title IX process. Major responsibilities include coordinating awareness, prevention, climate monitoring, training various groups of the campus community, developing compliant policies and procedures, creating reporting mechanisms, evaluating complaints, monitoring and implementing supportive measures, ensuring compliance with final sanctions, and maintaining records. However, key points are that according to the Title IX final rule made effective in August 2020, the Title IX coordinator should not be the investigator nor the decision maker who issues the findings after an investigation has been completed. Okay, next slide, please. So how can we help? How could this office help you when it comes to a Title IX complaint? Well, we could offer you the following supportive measures, such as no contact orders, class schedule changes for students, work arrangements for employees, and referrals to counseling and health services. We're also committed to ensuring that the investigation process is fair and unbiased. Lastly, we could also provide you referrals to both internal and external resources to support your well-being. Okay, next slide, please. So now let's look at a very significant piece of the regulation, mandatory reporters. Next slide, please. So here at Southwestern College, officials with authority are the mandatory reporters who must report potential Title IX violations when they receive knowledge of those concerns. Officials with authority are not confidential resources, and they're required to report sexual harassment allegations to the Title IX coordinator promptly. Meanwhile, all other employees are encouraged to report allegations to the Title IX coordinator, but they are not required to do so. So here's a list of officials with authority at Southwestern College. Please note that according to college district policy, the director of employee relations and Title IX is the Title IX coordinator. Also, all individuals identified as supervisors under California's Fair Employment and Housing Act are officials with authority. Okay, next slide, please. So who can you tell? Well, here is a list of contacts for you to reach out to if you have concerns related to a Title IX violation. They include officials with authority, the Title IX coordinator, campus police, and we've even included some external community resources such as the hotlines for Center of Community Solutions and RAIN, which are organizations that support sexual assault, sex discrimination victims. Okay, next slide, please. I want to briefly talk about Title IX statute of limitations. Like all legal claims, there are strict time limitations within which a Title IX claim must be filed. This is known as the statute of limitations. Now, because Title IX does not explicitly state a statute of limitations, courts will apply the statute of limitations set forth in the comparable law of the state governing the Title IX claims. So, for instance, the statute of limitations under Title IX will vary from state to state, and in California, it would be 2 years. And generally, the statute of limitations begin to run when a complainant knows or has reason to know of the injury on which their claim rests. However, some federal courts have held that the statute of limitations under Title IX does not begin to run until the complainant knows or has reason to know that the school played a role in causing the complainant's injury. So, you know, in terms of this topic, there is a lot of divergent opinion and legal precedents on this issue, which often requires a deeper drill down. And the 2 years that I cited, it is something that was that we obtained from the personal injury law of California, because in personal injury law, the 2 years is a statute of limitation for those types of lawsuits or claims. Okay, next slide, please. So how can you help a victim of potential Title IX misconduct? Next slide, please. Here are some pointers on what you could do to help a victim of potential Title IX violation. You can make sure they are in a safe place. Listen, but do not press for details. It's very important to understand that trauma can interfere with a victim's memory and recall. You could also encourage the victims to seek help and medical attention right away, and to contact campus police or local police if they're in crisis or feel a crime has been committed. But the major takeaway is that if you are an official with authority, you know, one of those individuals that I clarified on in one of the previous slides, you must follow the mandatory reporting procedures. That means you must report the incident to the Title IX coordinator, which would be the Director of Employee Relations on Title IX here at Southwestern College. Otherwise, as an employee who is not an official with authority, you are encouraged to report to the Title IX coordinator. And I just want to note that we talked about this yesterday. Due to the COVID-19 global pandemic, there has been a rise in domestic violence incidents, according to numerous studies, and it's really largely a result of the stay-at-home orders and the lockdowns that were issued in response to the pandemic. So it's more important than ever that when you know of a incident of domestic violence, that you try to help the survivor by making sure that they could get to a safe place, and that they understand the resources out there available for them to utilize. Okay, so next slide, please. So as we end this presentation, again, we'd like to remind everyone that it's really on all of us to be proactive in addressing these sex-based inequity issues. We need to understand that domestic violence is a big issue, that non-consensual sex is sexual assault, that sexual harassment is sex discrimination. These are, by understanding that and raising awareness, that really brings these matters to the forefront, but people recognize that we need to address them. Also, please be aware of situations in which sexual harassment may occur, and that's on, off, or related to the campus. You could try to intervene in situations where consent has not been given, and really participate in this community to create an environment in which sexual harassment is unacceptable. And by all of you attending this training today, this presentation today, and that really shows that you are making an effort to participate and to create this awareness that sexual harassment is unacceptable. So by doing these things, this would help our entire Southwestern College community to combat sex discrimination and gender-based discrimination, and make our community a place where everyone can thrive. And that includes, students, employees, community members. Okay, next slide, please. Well, thank you very much for attending this presentation, and a big thank you to Yan for helping me with the logistics. If you have any questions or comments, please do not hesitate to email us at the email addresses posted. And I really hope you have had a enriching session here, and that you have a great rest of your day. Thank you so much.